You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
What happens when a murder defendant picks up another charge while out on bond? When a man claims he's a victim after punching a stranger who tried to protect two women from his harassment? When a drunk driver gets caught with multiple open containers, cold to the touch, after already being on bond for a previous case? And when a father with 7 kids gets slapped with protective orders he cannot violate under any circumstances? Welcome to one of the most intense courtroom sessions we've ever covered. Today, Judge Fleer is drawing hard lines in sand. Bonds are getting revoked. Defendants are getting sent straight to jail. And some of the most powerful lectures about addiction, accountability, and consequences are about to be delivered. From oxycodone warnings to capital murder of misdemeanors, you're about to witness justice being served with absolutely no mercy for repeat offenders. This is courtroom accountability at its most raw. Let's break it all down.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case.
Let's unpack what just happened here, because this is layered. Ms. Taylor is already out on bond for murder, one of the most serious charges you can face, and now she's caught up in an assault case at a nursing facility. The allegations? She was trying to get her grandfather, who has been diagnosed with dementia, to sign over power of attorney. The nursing staff refused to allow it because someone with dementia cannot legally consent to such documents. When they tried to stop her, she allegedly pushed a nurse's face. Now here's the legal reality. When you're out on bond for a serious felony like murder, you're supposed to be on your best behavior. You're essentially on borrowed freedom. Any new charge, even a misdemeanor, can trigger bond violations and send you straight back to custody. And this judge, he's already making it crystal clear that he's not playing games. Watch how this unfolds.
Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the...
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
it looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she? I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the CVR was submitted, Stephanie, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paperwork right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, her curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again,
Sure.
this is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
This is the moment that defines everything. She's lucky to even have a bond. Let that sink in. When you're charged with murder and a judge grants you pretrial release, that's not a right, that's a privilege. And what did Miss Taylor allegedly do with that privilege? She picked up an assault charge, violated her GPS monitoring conditions, and now her attorney is scrambling to explain why curfew times were conflicting. Here's the legal reality the defense is trying to work with. The magistrate set one curfew from 7 p.m. to 7 a.m., but the felony condition said midnight to 6 a.m. Those don't align, and that created confusion. But watch how the judge responds. He's essentially saying, I don't care about the confusion. You follow the stricter conditions, and then come to court to sort it out. You don't just do whatever you want and hope for the best. This is what accountability looks like when the stakes are life or death. Literally. The judge is deliberating whether to revoke her bond entirely.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
Thanks, Coach John. And my assumption is we're going to reach out to felony. My assumption is there's BVR valve for that too. So I don't know what it looks like, but.
I don't know, Michael. I'm going to stew on it for a while. You
Yes,
want to talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're almost
no
done.
problem, Judge.
Good morning, Mr. Randolph. So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you can, one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer was dispatched from a assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant
talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain and then grabbed the defendant, and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor. I was out. I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
It was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
Why can
understand?
you protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
No. Exercise.
And I'm
the right.
running from these people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want.
I just want to also be safe in your community also.
Don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be. No drugs, nothing. Enjoying a beautiful day for my mama's funeral. I know no news. I don't know these people.
Listen, I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on.
Okay, we need to talk about what just happened because this was intense. Mr. Randolph is charged with assault after allegedly harassing 2 women on the street, chasing one of them when she tried to run, and then punching a bystander who stepped in to protect them. But listen to his defense. They were a danger to me. He claims he just did 4 years in prison. He's tried to do good, and now he's going through the same thing again. He even mentions it was his mama's funeral day. The emotion is real, but here's what the judge is doing. He's trying to stop this man from incriminating himself. You're going to say something that hurts your case. Just stop. That's not the judge being mean. That's the judge literally trying to protect this defendant's legal rights. Everything said in that courtroom is on the record and can be used against him. The judge is essentially saying, I hear you, but right now, silence is your best friend. This is a perfect example of why the right to remain silent exists. Sometimes your biggest enemy in court is your own mouth.
We're on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. A law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have anything and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, I don't have anything unquestioned about his whereabouts, and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. Due to the defendant, 0 out of 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk and turn. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of Modelo beer and an empty Twisted Tea alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here, Your Honor. I'm not unsure if that meant that he did not have the license at the time.
I don't mind running it, please.
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Juarez 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to biweekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not to drive as well. I mean, he's got alcohol in the, no, it's not going to happen. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez, and he's got a bond violation report, Your Honor.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay. Those of you. Sorry, Maria. All right. We're going to keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001. We'll just raise it to 1,001.
6,000.
It's 5,000 now,
Right.
so I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out,
Yes, Judge.
And there it is. The hammer drops hard. Bond revoked. Mr. Juarez is going to jail today. Let's break down why this was inevitable. He was already on bond for criminal mischief. The court had been testing him twice a week for alcohol, and his attorney says he was doing pretty good. But then he allegedly runs a red light, nearly hits another car, drives past multiple parking lots trying to avoid the traffic stop, and when officers finally contact him, he's incoherent, can't provide his name or date of birth, and there are multiple alcohol containers in the vehicle, 2 unopened six-packs cold to the touch, an empty 24-ounce beer, and an empty twisted tea. Cold to the touch means recently purchased. This wasn't old evidence. This was active consumption. The defense tried. Would the court consider going back to bi-weekly testing? And the judge's response? It's damn elementary that you're not supposed to have alcohol in the car while driving. He called it elementary. Like this is basic. This is first grade level understanding of bond conditions. When a judge uses language like that, you know all patience has officially evaporated. No more chances. Jail. Period.
good morning, Mr. Ayler. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay. Any private APIs?
Yes, Your Honor, out of a different county.
Is it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, what'd you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have you go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is eligible.
Great. Okay, come on. Mr. Bustamante, I know that there are 2 sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number 1, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly. Mr. Bustamante, I want you to listen and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective order case. That, in and of itself, is the capital murder of misdemeanors. Do you understand? You violate conditions on that, I can have a hearing to hold you at no bond.
I understand 100%, sir, Your Honor.
The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever, maybe smoke signals. No means no.
It's not a problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones. I'm a good daddy.
Don't talk to these 2.
I understand, Your Honor.
This order only applies to these 2. Don't use the other kids to try to have contact with these. If you do,
We all live together. Right.
now you don't.
Right. I'll go to Mom's house.
Best go somewhere else because they're going to inform those kids now that you're not supposed to be there or have contact with them.
That's not a problem, Your Honor.
All right.
The first one, my daughter, she doesn't live here. She ran away with her husband. Whenever she called the cops, she wasn't even at the house.
I don't.
Understand?
Don't go into
You
the
have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm going to blow a gasket.
That's done. You got it.
State, is there anything else?
Yes, Your Honor. There are allegations of drug use too. We would ask for reading your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question,
Ask
actually?
the lawyer.
Okay, so, okay.
Okay.
We're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on. That's it.
Thank you, Your
Okay,
Honor.
so we need him to sign conditions
Yes,
with
sir.
Roxanne whenever she's ready.
You come up here so I can.
I'm not equivalent. I want to go.
Please.
I want to go to jail.
This right here is one of the most crucial lectures we've seen in this courtroom. The judge just called protective order violations the capital murder of misdemeanors. Let that phrase sink in. He's saying that violating a protective order is the worst thing you can do in the misdemeanor world. So serious that he can hold a hearing to keep you locked up with no bond at all. And Mr. Badmanny? He's got 7 kids, and 2 of them are now protected individuals he cannot contact under any circumstances. No phone calls, no texts, no social media, no Snapchat, no emails. The judge even said no smoke signals. And when Badmanny says we all live together, the judge's response is ice cold. Right? Now you don't. This man has to find somewhere else to live immediately. He can't use his other kids to relay messages. He can't go within 200 feet of where they live or work. The stakes couldn't be higher. You pick up a third case, I'm going to blow a gasket. That's judge speak for you're done. This is what it looks like when the court draws an absolute line in the sand and dares you to cross it.
Good morning, Mr. Godine.
You know, sir.
Sir, you're charged with driving while intoxicated You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted to running the red light. Standard field sobriety tests were conducted. A 2 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant estimated 30 seconds passing and what was in reality 72 seconds on the one-leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a .00. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant, a narcotic, an analgesic, and cannabis. Thank you, Your Honor. And the defendant admitted he took oxycodone or narcos and smoked weed. A blood warrant was obtained and executed.
Mr. Goda, and I'm going to find that there's sufficient probable cause to go forward to the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find it becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail, and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it. You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week, I'm going to test you because I want to make sure you're not using. Do you understand?
Sir.
Don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. Do you understand?
Yes, sir.
License, prior DWIs?
The license is eligible.
Okay.
And not seeing any prior DWIs here, Your Honor.
I'm telling you that I've had probably a handful of friends that have died from Oxy because they continue to take it, build up that tolerance, and put their lungs to sleep. It's disgusting. Just don't. Do you understand?
Yes, sir.
I don't want you to kill yourself. Life is way too short.
Yes, sir.
You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand?
Sir.
Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Ms. Barks, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well.
And that is how you end a courtroom session, with a judge sharing personal loss to save a life. He just told Mr. Godine that he's lost a handful of friends to oxycodone overdoses. They built up tolerance, took too much, and put their lungs to sleep. That's not legal jargon. That's a man speaking from genuine pain. Try to prevent another tragedy. Asterisk. Asterisk, let's recap what we just witnessed across this intense session. Asterisk. Asterisk, Miss Taylor, already on bond for murder, picked up an assault charge in a nursing home while allegedly trying to get her dementia-diagnosed grandfather to sign over power of attorney. The judge is stewing on whether to revoke her bond entirely. Asterisk. Mr. Randolph punched a Good Samaritan who tried to protect 2 women he was allegedly harassing on his mother's funeral day and nearly talked himself into deeper trouble before the judge stopped him. Mr. Juarez got his bond revoked and was sent straight to jail for a DWI with multiple open containers while already on bond for another case. Asterisk, Mr. Bam Andy received protective orders so strict that he can no longer live in his own home with his 7 children, and was warned that a 3rd case would make the judge blow a gasket. Asterisk. And Mr. Godine got the most personal plea of all, a judge begging him not to die from oxycodone addiction. Asterisk, this is justice with humanity, accountability with compassion, rules with real consequences, Asterisk. Asterisk, now I want to hear from you. Which case hit you the hardest? Should the murder defendant's bond be revoked? Drop your thoughts in the comments. Asterisk. Asterisk if this breakdown opened your eyes to how the justice system really works. Smash that like button. Share this video with someone who needs to see it. And subscribe to the channel for more jaw-dropping courtroom content. Hit that notification bell so you never miss another session. Until next time, stay safe, stay smart, and we'll see you in the next one.